Okay, folks, are we okay to start the webinar? Here we go.
Hi, everyone. I'm Sharon D'Souza. I'm your National Executive Vice President of the Public Service Alliance of Canada. And first, before we begin, I'm just going to turn it over to Chris from Encore, who's just going to give us a couple of tips on how to use Zoom. Chris?
Hi, folks. So I'm just going to run you through the menu of Zoom here, so it'll be easier for you to follow along. So you'll see in the bottom menu, there is an interpretation feature. If you look over to the globe icon that says interpretation, you can click on that and choose either off, which is the floor, English, or French. And if you only need English, just stay on English for the duration of the meeting. The same with French. So there's going to be a Q&A later on in the last half hour, I believe, and you can ask questions using the Q&A feature. You will only be able to view the answered questions, and your questions will be moderated. There is no possibility of using the chat in the chat feature. It would all be done through the Q&A. And I believe that is it. Over to you, Sharon.
Thank you, Chris. So today I'm speaking to you from Toronto, which is on the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabeg, the Chippewa, the Haudenosaunee, and the Wendat peoples. This land is still the home of many Indigenous people from across Turtle Island, and I'm grateful to speak from this land. Happy Black History Month to you all. It's an honor to be here with you today. The PSAC represents more than 200,000 workers in every province and territory in Canada and locations around the world. As a member of PSAC, you can count on being well represented. Over the years, we have demonstrated we know how to defend the rights of employees and how to expand those rights through collective bargaining, legislative, and legal action. Anti-Black racism exists in all of our communities, in our organizations, in our institutions, in our workplaces, and in our unions. We must end anti-Black racism. Uprooting and dismantling anti-Black racism is everyone's fight, and this remains a priority for our union. To create real and meaningful change, we must accept that inequities do exist and that we must do the work every day to dismantle the structures that have upheld these inequities for centuries. We must actively work to change the practices that have often led to the marginalization of Black Canadians. I want to thank you all for joining us today as we will be discussing a very important element of our union work. We will be hearing from our recourse mechanisms available for racism and racial discrimination and the ways in which they have often failed Black workers. With the recent class action lawsuit filed against the Federal Public Service on behalf of 300,000 current and former Black federal public service employees, it does make us wonder, why are recourse mechanisms within the workplace not adequate? What can we do to make sure that these mechanisms work better for Black workers? We must look at ways in which we can break down barriers and better represent our members. We recognize that we have to actively challenge our own practices every day in order to be there for our members and their needs. As part of that work, we must honor and celebrate the contributions and lived experiences of Black Canadians. Black history is Canada's history. Black workers matter, and Black lives matter. I will now turn it over to Craig, but before I do, I would like an opportunity to introduce him, and it's a great privilege. Craig Reynolds became the Regional Executive Vice President for Ontario on September 2020. He's born in St. Elizabeth, Jamaica. Craig immigrated to Canada with his family when he was 19. In 2004, while studying business management studies at York University, Craig joined the Federal Public Service through a term employment at the Immigration and Refugee Board. There, he soon realized that many of his coworkers were caught in a cycle of precarious employment, ranging from short-term contracts to term appointments and casual work. To fight against this injustice and other workplace issues, Craig got involved in his union local, serving as president between 2013 and 2020. He was also active in his component, the Union of National Employees, and on PSAC Ontario Regional Council. Craig is committed to engaging and mobilizing PSAC's growing and diverse membership. He has pledged to improve our members' working condition, along with organizing new workplaces, empower young activists, and fight to dismantle systemic racism. Once again, thank you for having me here, and thank you to the organizers, and happy Black History Month. Over to you, Craig.
Thank you very much, Sharon, and welcome to everyone tonight who is joining us. I'm very excited to be here tonight. We have an amazing panel of speakers with extensive experience on tonight's discussion on recourse mechanisms for Black workers. On tonight's panel, we have Samantha Peters, Amarkai Laurier, and Douglas Hill. Samantha Peters is a lawyer, researcher, and educator whose work focuses on labor, employment, and human rights law. She is also the Black Legal Mentor in Residence at the University of Ottawa Faculty of Law for the 2020-2021 academic year. Samantha engages in work at the intersection of law, education, and policy, ranging from law reform initiatives to legal education on legislation research. She is the Director of Legal Initiatives and Public Interest at Black Femme Legal, a project funded by the Law Foundation of Ontario, which provides legal and non-legal resources and support to Black 2SLGBTQI+ workers across Ontario through Black femme-centered approach, lens, and praxis. She is the National Vice President of Equity and Anti-Oppression at the Canadian Association of Labour Lawyers, a member of the City of Toronto's Lesbian, Gay, Bisexual, Transgender, Queer, and Two-Spirited, which is LGBTQ2S+, Council Advisory Body, and a pro bono lawyer where she provides free legal advice, brief services, and referrals to women identified survivors of domestic violence. Samantha's writing on topics such as intersectionality, Black women in the law, and judicial education has appeared in Flair, Huffington Post, Canada, SLAW, The Lawyers Daily, and Canadian Centre for Policy Alternatives, to name a few. In 2020, her essay titled Making Social Context Education Mandatory: Why Cultural Competencies Should Matter in the Courtroom won the Canadian Bar Association's Women Lawyers Forum's inaugural Writing Her In competition. Welcome, Samantha. Our next panelist, Amarkai Laurier, works in the Representation and Legal Services branch for the Public Service Alliance of Canada, PSAC. He has appeared before labor arbitrators and administrative tribunals throughout the country, representing PSAC members and the union on a wide range of issues. In addition to having served as a union local executive, he has also worked in the Strategic Affairs Department of an international union, Unite Here, and for the Canadian Industrial Regulations Board. He holds BCL and LLB degrees from McGill University and was called to the Ontario Bar in 2004. He is a member of the Canadian Association of Labour Lawyers, CAL, and the Black Legal Action Centre. Welcome, Amarkai. Our final panelist, Douglas Hill, is a grievance and adjudication officer who has 17 years of experience in litigation and mediation from working in the Representation and Legal Services branch of the Public Service Alliance of Canada. His duties and responsibilities include representing PSAC members before various arbitration and adjudication tribunals on issues concerning their grievances and human rights complaints. Douglas is a non-lawyer advocate who has many legal victories, which include the following: Gerson Heffernan versus Canada Border Services Agency, Dyson versus the Department of Fisheries and Oceans, Dora versus Canada Revenue Agency, and Reeves versus the Department of National Defense. Douglas is a proud father of 3 children and a former basketball player at Dalhousie University. His love of golf and advocating for people's rights led him to become one of the founding members of Black Lives Matter Golf Initiatives in 2020. Thank you to our panelists for joining us this evening. Let's begin our discussion. So, what are the recourse mechanisms and what are some of the issues with the mechanisms that make them less favorable to Black workers? And tonight we will start with Amarkai. Amarkai?
Thank you. Thanks for the introduction, Craig. My pronouns are he and him, and I'm honored to be a guest here on the traditional unceded territory of the Algonquin Anishinaabe people, referred to some as Ottawa. I'm also happy to be here with everyone on the panel, and so thanks to the organizers, interpreters, and to all of you for taking the time out of your evening to be actively here. So parts of this discussion tonight will be in French, so I may be jumping back and forth from English to French. And I'll actually start in French now. So if you want to make sure you have your interpretation ready. Lorsque nous parlons de recours pour les travailleurs,
when we speak about recourse for Black workers in the workplace, I think it's important to look at it in a historical context. And what I mean by that is that I'm talking about anti-Black racism. Anti-Black racism in its systemic and individual forms is alive and well. We cannot even question that fact. If you were in denial at one point, this past year has shown you something. In this North American context, we can trace anti-Black racism to the slave and transatlantic slave trade and white supremacy, among other things, where African descendants were taken from their lands and forced into work. Even after the end of slavery, we experienced Black segregation in Canada that was justified through legislation for years and years. The laws that put that into place were influenced by the opinions of society, and they perpetuated the ideas of racial inferiority used to justify Black slavery from the very start. Yet today, we are still suffering the consequences of this story, and I will call their names: Abdirahman Abdi, Breonna Taylor, George Floyd, and others. Racism, and especially anti-Black racism, anti-Indigenous racism, is part of community thinking. This phenomenon has negative impacts and direct impacts on the workplace. We cannot pretend that the workplace is different and separate from society and is free of systemic and individual racism. It manifests itself absolutely in the workplace. We see it in hiring and promotion practices, in management decisions, in interpersonal relations between colleagues, and also in the unions. Therefore, when we look at reports such as the Public Service Report published recently, it shows that among the racialized subgroups studied, there was a lowering of representation among Blacks than in other groups, in pre-selection, right to assessment and evaluation steps. This is not surprising. These are the same results as came out in the 70s. It's part of the historical path of anti-Black racism, what we call racial capitalism. Also, if you look at intersectional analysis, you see even worse results for Blacks who have a handicap, who suffer from a handicap or a disability. This evening, as we speak about what we have available to us in the workplace, we need to talk about this fight against Black racism. We need to begin and speak about fighting against discrimination in the workplace as systemic battles against white supremacy and anti-Black racism. If we see it in that lens, we take away the individual nature of the incidents and we place them in a historical context that involves the fight for dignity, respect, and the well-being of Black people.
To go into examples of some recourse mechanisms that are available, but in general, the main ones that we tend to see in the workplace include informal discussion, grievances under a collective agreement, human rights complaints, mediation, conciliation, negotiations, complaints under a workplace anti-discrimination policy, complaints under occupational health and safety legislation, union management consultation committees, workplace mobilization, courts, and mental health resources. But we also have to recognize that most of these recourse mechanisms are still within that Dominic historical framework that I was talking about. So I'll stop there and have my colleagues go into some examples of these recourse mechanisms.
Thank you very much, Amarkai. That was very informative. Doug, do you want to chime in?
Yes, thank you. My name is Douglas Hill. I'm a proud African Nova Scotian. I also would like to acknowledge the fact that I'm seated on traditional Mi'kmaq territory. And I'm also very grateful to be here as part of this panel discussion. I want to thank PSAC, all the organizers and the translators for putting this on, as well as you, Craig, for hosting this or being the moderator of this, in-depth conversation. As Amarkai stated, there are a number of recourses available for federal government employees dealing with anti-Black racism or racial discrimination in the workplace. One of the decisions that I'll get into a bit later has to do with the Christian Reeves decision. And Christian Reeves was a young Black man from Nova Scotia, worked for D&D, who had filed a grievance, filed a human rights complaint. The decision became public in 2019. It becomes one of the precedent-setting decisions today within the federal public sector. But Amarkai first mentioned informal discussions. And for federal government employees or any unionized person in your collective agreement, normally you have language in there to have an informal discussion with your supervisor on these issues before filing a grievance. And when those discussions fail, as they did with Christian Reeves, the next thing to do, or the next step, would be to file a grievance. And one of the things that you have to be aware of in filing a grievance is the time limits associated with that. Most grievances in collective agreements have a 25-day time limit to file your grievance from the time you become aware of the incident, or from the time that the discrimination occurred. Also, what's important with grievances are the wording of the grievance. We're going to talk later as to what are some of the barriers, but the wording of the grievance at the beginning is rather important so that our hands are not tied. Quite often, we find ourselves at adjudication where someone has grieved the fact that they have been terminated, but failed to articulate or failed to write in the grievance wording that their termination was associated with discrimination based on race. And as a result, we're unable to argue that particular issue. And so those are the two common barriers that we have, is untimely grievances and grievances that don't capture the proper human rights language. So in filing a grievance, you can also file a human rights complaint on the same issue. Human rights complaints have time limits as well. And with the Canadian Human Rights Commission, the time limit is 1 year from the time you become aware of the incident. But once again, the proper language is required. What the Human Rights Commission will do with your human rights complaint is give you what's called a Section 41A bounce back, or a letter stating that they will accept your complaint, but your human rights complaint will go in abeyance pending the outcome of your grievance, because you have that grievance mechanism to work for you. And adjudicators now have the jurisdiction to award human rights damages. So you have an informal discussion, you have a grievance process as a mechanism, you have a human rights complaint as a mechanism. And a fourth mechanism that you have is mediation. Mediation usually occurs, can be either formal or informal. It occurs through the board, the Federal Public Sector Labor Relations and Employment Board, and usually occurs after you file a grievance. Your grievance is scheduled for adjudication. They will ask whether or not you're interested to mediate your complaint. And the things you have to understand about mediation, that number one, it's voluntary. And number two is that if you are able to resolve your complaint at mediation, it's confidential. And this is one of the reasons why we don't hear about so many issues or so many public decisions, because quite often the employers want to resolve these issues. I'm representing a woman out of Ottawa right now. Her name was in the newspaper a few months back, and that is Andrea Kenny. Andrea Kenny also works with D&D, and she faced anti-Black racism when she experienced a poster using the N-word was placed in her work environment. Andrea had informal discussions with her employer. Andrea filed a grievance alleging discrimination on the prohibited grounds of race. Andrea filed a human rights complaint. The grievance is now at the board. But before we go to the grievance hearing, the board asked the parties whether or not you want to resolve this. Well, of course they want to resolve it. It was asked of them before, but once this story hit the media, only then did the employer really take it serious, and the senior military official was then suspended, is now being investigated. But mediation is also a mechanism that you can use as well. One other thing that I wanted to talk about was that as a mechanism was mental health resources. Mental health resources can be used as a mechanism. And one of the decisions that Craig mentioned, the Marilyn Duro decision, Marilyn Duro dealt with the issue of sexual harassment in the workplace, and she received precedent-setting damages. She received the maximum damages allowed under 2 articles of the Canadian Human Rights Act. But in addition, she also received and was reimbursed all of her medical expenses that she was treated for seeing a psychologist. This is a public decision. And so the adjudicator reimbursed her over $22,000 in medical expenses. Another decision out there called Juliet English Baker, that decision dealt with a woman who suffered from a mental disability, I believe schizophrenia, and she had an episode in the workplace. The employer was well aware that she suffered from this medical condition. And when she had an episode in the workplace that really disrupted the workplace and upset the water cooler, what the employer decided to do was they decided to discipline her. The adjudicator ruled that disciplining someone for non-culpable behavior was discrimination on the prohibited ground of mental disability. Juliet English Baker happened to be a Black woman as well in the city of Ottawa. So utilizing the health resources to seeking medical assistance is really important, especially in this day and age. There's a great deal of talk with respect to mental health. But those are 5 of the recourse mechanisms that I would speak about that Armachai gave the greater overview. And I'll pass it over to Samantha Peters now, and she can pick it up from here. Thank you.
Thanks for that, Doug. Samantha, what are your views?
Hi, everyone. My name is Samantha Peters. My pronouns are she and they, or elle ou yel. I also wanted to say that I'm currently located on the unceded and unsurrendered traditional territories of the Anishinaabe, Adirondack, Mississaugas of the Credit First Nation, Huron-Wendat, Mississauga, and the Haudenosaunee, also known as the City of Toronto. So I just wanted to be able to let folks know where I am speaking from. And for folks that may want to know how to find out which territory that they are on, you can go to www.native-land.ca. So I think that's a really helpful resource for folks to consider using. Before I respond to the question, I just wanted to give a couple of definitions of terms that I will use throughout so that it makes sense of what the things that I will be talking about. I'll be talking about anti-Black racism. And essentially, anti-Black racism is defined as policies and practices rooted in Canadian institutions such as education, healthcare, and justice that mirror and reinforce beliefs, attitudes, prejudice, stereotyping, and or discrimination towards people of Black African descent. And the term anti-Black racism was first expressed by Dr. Akua Benjamin, a Ryerson social work professor. It seeks to highlight the unique nature of systemic racism on Black Canadians and the history as well as experiences of slavery and colonization of people of Black African descent in Canada. However, for me, it is also particularly important not to separate discussions of racism from white supremacy, as the perpetuation of white supremacy is racist. And this citation is from Grillo and Wildman in a 1991 piece called Obscuring the Importance of Race, the Implication of Making Comparisons Between Racism and Sexism or Other Isms. I'll be using perhaps the term misogynoir. So misogyny is the hatred of women, but misogynoir is the specific hatred, dislike, distrust, and prejudice directed at Black women. And it's coined by Black queer feminist Moya Bailey. And misogynoir is grounded in intersectionality with an acute awareness of anti-Black racism and sexism. I'll be using the word femme. Je sais que c'est un mot français, mais
I know that it's a French word, femme.
Presentation that leads towards femininity. So although commonly associated with like feminine, lesbian, queer women, it's used by many to describe a distinct identity and or expression and does not necessarily imply that one also identifies as a woman. So to be clear, femme includes trans, non-binary, and gender non-conforming folks and does not only apply to cisgender women. And so I'm a Black femme. And I would encourage folks to read a really beautiful piece written by Cortez Wright, and it's titled An Act of Knowing, Moving Towards a Black Femme Politic. So when I'm talking about recourse mechanisms, I'm really centering the experiences of Black femmes and Black women. And I'm going to be using this term that I call Black femme harassment. And this is a term that I coined. It can be identified as any unwanted physical or verbal behavior that offends or humiliates Black femmes. So the question would be, so what are some of the issues that Black women and femmes experience in the workplace, and what is Black femme harassment? And for me, it can range from the assumption that we are straight, and as a result, we are subject to hearing violent queerphobic and transphobic comments, to being touted as angry or strong Black women and facing disciplinary consequences as a result, to being viewed as a Jezebel, a harlot, or a video vixen and becoming victims of sexual assault or sexual harassment in the workplace. So to answer the question more directly, when we're talking about recourse, if we define justice within legal systems, then recourse mechanisms available to Black workers include what Amar, Kai, and Doug have mentioned, such as grievances, human rights complaints at the Ontario Human Rights Tribunal, if you're located in Ontario, complaints under workplace policy, et cetera. However, in my opinion, there are limitations. So for instance, at the Ontario Human Rights Tribunal, despite you possibly wanting to keep your identity anonymous for whatever reason, there's no guarantee that the HRTO will allow this. So in fact, the HRTO has denied anonymization requests when they believe that there is no privacy interest or that there were no significant risks to privacy interests. And so for anonymization requests, which means like having your initials used instead of your full name to be approved, the HRTO must be satisfied that personal privacy outweighs public interest. But in my opinion, legal recourse does not always take into account how re-traumatizing the process can be, how expensive it can be, emotionally taxing, time consuming, et cetera. So on the flip side, recourse does not have to equal punishment, and sometimes accountability can mean healing and does not have to be re-traumatizing. So as such, recourse mechanisms available to Black workers outside of legal systems and that centers healing could include things like therapy, yoga and exercise, meditation, mental health supports, which is something that Doug was talking about, support system, 24/7 peer hotlines, things like that. And an example is Blackline. It's a 24/7 volunteer run hotline that accepts calls and texts, that provides a support for a space for peer support and counseling, reporting of mistreatment, and affirming the lived experiences of folks who are most impacted by systemic oppression through a LGBTQ+ Black femme lens. But it's also important to note, however, that accountability can also be different depending on where we work and whether our job is precarious, whether we need the job, whether we need to get paid, et cetera. So accountability can be and or, meaning it can be legal and non-legal recourse, or it can be one or the other.
Wow, thank you so very much for that, Samantha. This discussion is going along very well. My next question is, with so many different recourse mechanisms in place, why are there so few successful cases of racism and racial discrimination? And with that, I want to start with Doug. Doug?
Thanks, Craig. I think to look at why there are so few successful cases, we should first look at one of the most successful cases, which is Christian Reeves' decision. And just briefly, Christian Reeves was a Black man working for D&D in Halifax and was terminated and then reinstated after 5 years and received 5 years of retroactive pay and benefits. He was also awarded damages under the Canadian Human Rights Act under Section 53(2) for pain and suffering in the amount of $15,000. And the adjudicator ruled that there was an assault on his dignity and found it particularly disturbing the clear campaign that was mounted against Christian. For example, testimony sought to show him in bad light, differential treatment, lack of mentoring. The adjudicator also ordered damages under another section of the Canadian Human Rights Act for the employers willful and reckless behavior in the amount of $10,000. So in this particular case, which is one of the leading decisions at the Federal Public Sector Labor Relations and Employment Board, the adjudicator applied the three-part test. The three-part test in establishing discrimination on the prohibited grounds of race has to do with, number one, establishing that there's a prohibited ground. In Christian's case, it had to do with the fact that he was Black and his ethnic origin. So he had two prohibited grounds. The second part of the test had to do with the adverse impact, which was the termination or the rejection on probation. The third test, the third element of the test, which is the most difficult to prove, is the nexus or the connection between the prohibited ground and the employer's actions. In other words, they terminated him because he was Black. That's the difficult test to prove. And the reason why it's difficult to prove is because, number one, quite often the employer will give a false pretext or a false explanation for why they took the action that they did. They will give a false bona fide occupational requirement for the discrimination. Another reason why there are so few successful cases has to do with the implicit bias that, as Armakai mentioned, that is in the structures, the systemic racism that's within the structures of the adjudication process. The fact that there's mostly white adjudicators, predominantly white male adjudicators, white witnesses, white lawyers. Christian Reeves was really a very strong individual despite those circumstances. He had an inner strength about him. And one of the things that I asked myself in reading the Christian Reeves decision and representing him was that, would we have been this victorious if it was not for the white witnesses that actually came and testified on his behalf? Those people that were asked to lie about Christian testified on his behalf. True allies to our cause. But the other thing that I realized is that in this particular case, the adjudicator was, although she was white, she was a female who was Francophone and had a very clear understanding of, and a clear lens of, the issues of bias and discrimination. And she applied those to the Reeves decision and gave a great decision in that case. Another reason why there are so few success stories, although the Christian Reeves decision is out there and the Andrea Kenney decision or mediation is out there, there are a number of people that I have represented in the federal government that have resolved their complaints. And as a result of resolving their complaints, they don't become public decisions. They become confidential decisions. The employer wants to hush them up with some money. Discrimination occurred. We don't hear about those because they decided to resolve them and they remain confidential. You know, I think if we're honest with ourselves, that we have to look closely at ourselves as a union, starting from the local, with the component, even with PSAC, because there are situations that occur. You mentioned the Craig Dyson decision. Craig Dyson was an Indigenous person. His decision went to the Federal Court of Appeal. Craig Dyson was reinstated on a rejection on probation, but when we got to the adjudication, he wanted to argue discrimination on the prohibited grounds that he was in fact Indigenous. But unfortunately, my hands were tied because his grievance didn't have the wording. He was not given the correct information at the beginning of his grievance. Therefore, the adjudicator did not have the jurisdiction. Even the Christian Reeves decision, as wonderful as it is, did not allege systemic discrimination. I wanted to argue systemic discrimination, but it did not allege systemic discrimination. It only alleged discrimination on the prohibited grounds of race, and it was individual discrimination. So quite often, when the grievance is not worded properly, as grievance and adjudication officers that represent these people before adjudication hearings, our hands are tied. The employer raises preliminary objections under a decision called the Birchill decision, preventing us from broadening the scope of the grievance, preventing us from broadening the corrective action of the grievance. You can do it. Not everyone has to be as sophisticated in the proper wording of the grievance, but if someone wants to file a grievance, that's wonderful. They capture it. As long as you, even if you don't allege discrimination on the face of the grievance, but if you do raise it, by the time you reach the 4th level of the grievance hearing, you then have broadened the scope of your grievance and you're allowed to argue an adjudication. So we have to look backwards and provide proper training with our unions, training on anti-Black racism, training for our local unions, training for our local components on this issue that continues to rise, because in my 17 years, the 2 most common preliminary objections from the employer's counsel is, number 1, the grievance is untimely, and number 2, the Birchill decision, which prevents you from actually broadening the scope of the grievance. So those are some reasons why, including mediation. It's not that the issues aren't out there, because they are. Mediation, proper wording, implicit bias, false pretext, the 3-part test, those are reasons why we have so few, some of the reasons why we have so few successful cases. And I'll put it over to Armika.
Thank you very much, Doug. Having heard what Doug said, Samantha, what are your views on this?
Thank you. I think that there are so few successful cases of racism and racial discrimination because it requires institutions and those who benefit from the system to be accountable. And in some ways, it's what I call systemic gaslighting, which is when governments and officials attempt to make Black folks question our own reality and memory or perceptions with respect to what is happening by trying to convince us that our realities are not real. And that's why for me, it was really powerful over the summer to witness so many Black women and femmes come forward on social media platforms like Twitter and share their experiences of anti-Black racism and misogynoir in their workplaces and in their respective industries. And what this did was really disrupt systemic gaslighting. However, I would be very simple in my analysis to say that there are few successful cases where, as Doug mentioned, the reality is that many cases of anti-Black racism in the workplace are solved via closed settlements and non-disclosure agreements in mediation, meaning that there will be no public record or legal precedent to rely on. And again, this connects to systemic gaslighting. But other reasons that there are so few successful cases of racism and racial discrimination include missteps by union representatives who do not understand anti-Black racism and its intersections with other identity markers and therefore cannot offer the necessary supports to Black workers. And also Black women and femmes being programmed to be a strong Black woman in the workplace and therefore having to exist and accept toxic workplaces. And, you know, as Doug has said, I've read tweets where labor lawyers have complained about potential adjudicative bias at arbitrations due to the resistance of having Black labor arbitrators hear cases of anti-Black racism. And for me, what that really makes me think of this is this RDS case where it talks about reasonable apprehension of bias. And because the Black woman judge, Justice Sparks, that was hearing a case was Black, and the case had to do with a Black Nova Scotian kid, she was accused of reasonable apprehension of bias, that she was biased in her opinion to oversee a hearing that was specifically about anti-Black racism. So for me, those are the reasons why there are such few successful cases that we know about.
Thank you, Samantha. Amarkai, do you want to weigh in?
Yeah, sure. I'll weigh in, and I agree with Samantha and Doug. I mean, the employer is responsible for ensuring a workplace that is safe and free from discrimination and free from anti-Black racism. The contradiction that I see that employers are faced with is, how do you change a structure from which you benefit from? And this is what all employers have to deal with. So for most of these recourses, the employer is often the first and the last person to respond to these complaints in terms of any internal process. So I don't think we could ever, and we should ever let the employer off the hook. And the reality is that it's often after workers have actually exercised their rights and use these recourses that employers are even forced to act. So when I think of the few successful cases, I also think we should talk about access to these recourses and workers exercising their rights. So questions like, do people actually have faith in the system? Do they feel any trust or safety in terms of sharing what was a really traumatic experience for them? Will the system understand their intersecting identities in a way that doesn't cause more harm? And so in saying all that, we also have to acknowledge the role that labor movements, unions particularly, can play as a barrier. Now, I know that a lot of my fellow Black colleagues and I have experienced numerous situations where Black members tell us they don't want to file a grievance because they don't have faith that the union truly understands what they're going through, or that they'll receive the adequate support that they need, or that at the end of this long and delayed process, they're actually going to see justice. And we hope that most union activists are able to identify and challenge direct forms of racism, which occurs in the workplace. But these days, especially, we need to gain a better understanding of the subtle forms that racism takes in our day-to-day activities, the microaggressions, the adverse impacts from perceived neutral policies. And our role as union activists is recognizing and supporting these actions. And I think it's directly related to this whole question of access. And there was a time when Black workers were systematically denied membership to unions and to representation. And I know folks out here probably heard the term, the duty of fair representation. So unions have a duty to act in good faith without discrimination or arbitrariness. Well, that term originates from a case back in 1944, Steele in Louisville, Nashville Railroad Company. And in that case, Steele, who was a Black employee of the railroad company, and he was not a member of the union because at that time, the white union excluded all Black employees from joining the union. And what that union did, without notifying any of the Black employees, negotiated an amendment in the collective agreement to exclude Black workers from promotions and permanent jobs. So Steele and the other Black workers said, no, you don't, and challenges. So they filed a court action. They went all the way to the Supreme Court, and it was held under the Railway Labor Act that if you're the exclusive bargaining representative, if you're the union, you have an obligation to represent all members who fall under the representation without discrimination. And so that's really the genesis of the duty of fair representation. And so once again, I would say like access itself is a barrier. And when we look at the labor regime, the reason we have grievances and arbitration is that the legislature believed that having a specialized regime for labor would be an efficient, fair, and cost-effective method of resolving workplace disputes versus going to the courts all the time. So that's why if you have a matter that's covered by the collective agreement, there's no direct access to the courts. And recently we've heard and seen that Black, Indigenous, and racialized workers are trying to use the courts to address systemic issues. I'm sure many of you have heard of the Black class action lawsuit filed against the federal government. And if you haven't, please go to blackclassaction.ca. That's one word, blackclassaction.ca. And the focus of the claim is on the hiring and promotion of Black employees in the public service, a term that they call Black employee exclusion. And this action is led by 12 plaintiffs that include unionized and non-unionized workers from various departments and agencies across the country. The majority of them were or currently are PSAC members. And if you go to the website, you'll find the names of the plaintiffs. You could read their experiences. And I'm sure some of you on this webinar will have shared similar experiences. And the class or group that could sign on to the claim includes all Black individuals who worked in the public service since 1970 up to today. And in the claim, it's noted how labor collective agreements and other legislations have been unable to appropriately address systemic discrimination. And there have been other similar court actions recently. There was a class action filed last month with Correctional Services Canada, and this was led by 2 Indigenous workers there. Last summer, the RCMP, there was also a class action dealing with racial discrimination. In 2019, there was a claim against the Ontario government led by 2 Black women regarding systemic anti-Black racism. And without going right now into the legal issues of each of those cases, for me, these claims are an attempt to say the current recourse mechanisms in the workplace are not working for Black workers, Indigenous workers, racialized workers, when we're trying to address systemic issues. And so that's definitely one reason they hold access issue. And another reason, as Doug was saying, are the decision bodies themselves, and Samantha had mentioned this too. In 2017, CUPE, so that's the Canadian Union of Public Employees, did a study on the diversity of labor boards across Canada. So the first step they did was look at websites, Google Images, LinkedIn. Then they approached the lawyers that were working in these different practice jurisdiction areas. And finally, they actually wrote letters to the labor boards asking the question about their compositions. And out of 129 chairs and vice chairs, that's 129 on these labor boards, only 4 were racialized and 1 identified as Indigenous. And we're not even talking about the hundreds of private arbitrators out there that we heard both Samantha and Doug talking about. And so, I mean, these results, these statistics necessarily have an impact on the experience and analysis that is brought into the whole decision-making process. And just 2 other points that I do want to raise in terms of what we see why cases are so successful is delay is one part of it too. Related to labor boards and proceedings are the delay it takes to get justice. So even when you look at cases that have been successful, a person has to survive for years before resolution, and they're re-traumatized through different stages of that process. And in some cases, the commissions themselves, such as the Human Rights Commission, they can be gatekeepers. They can be a barrier. So know with the Canadian Human Rights Commission, when you file a complaint, there's a first level of staff that review the complaint and then make a decision whether or not this should be forwarded to the tribunal. And so a huge complaint over the years, and which has also come from Black staff working at the commission, is why are there so many Black cases that are denied at this early stage of the process? So we see that even the recourses that Black folks often turn to for justice, the institutions themselves face the same systemic issues that we are fighting against.
Thank you so very much, Mark. Wow, just mind-blowing. I know we have a few questions coming in, and we will be addressing those questions in a few minutes, but we have one more question that I would like to pose to our panel. What does the future look like? How can we make recourse mechanism work better for Black workers? And with this, I'm going to start with Samantha. Samantha?
Thank you. First, we need to remember that legal recourse is a tool, but not the tool to making better possibilities for Black workers. So that is to say that there are options outside of legal systems. With respect to our legal system, one way that we can make recourse mechanisms work better for Black workers is by removing the 1-year timeline to file a human rights complaint, for instance, at the Ontario Human Rights Tribunal, when the court issue is anti-Black racism. I say this because what if it took you 2 years or even 5 years to be mentally prepared to go to the Human Rights Tribunal? Is it fair to be denied that legal recourse? And with respect to non-legal recourse, more financial investment into support supports that will protect the life and livelihood of Black peoples is one way to make recourse mechanisms work better for Black workers. And so bottom line, we can make recourse mechanisms work better by providing Black workers with all of our options, both legal and non-legal, by offering support and by being cognizant of the possibility of harm and trauma and cost going through that process. But in the meantime, as I've said, Black Femme Legal seeks to provide both legal and non-legal supports to 2S LGBTQ+ workers in Ontario who experience intersecting forms of anti-Black harassment, discrimination, and violence by folks who have lived experience with that. Thank you.
Thank you very much, Samantha. Amarkai?
I think being, working for unions, we could say the negotiation table is one way where we could fight back on some of these systemic issues. For example, we could have contract language about Black, Indigenous, and other racialized arbitrators being chosen to decide cases. That's something we could fight for in collective agreements. When we are negotiating around staffing, we could push more for the hiring and promotion of Black members. I also want to touch on health issues for a minute, because I know in June of last year, Ottawa's Board of Health voted unanimously to recognize racism as a public health issue. And it stated that racism, discrimination, and stigma are associated with poor physical, mental, and emotional health and a greater risk of death, making racism and anti-Black racism an important health issue. So if that's the case, and if it's a public health issue, I think we need to find ways to provide more support for Black workers going through the process in terms of their mental health. We also need to shorten the delays it takes to get justice, because this is a life and death situation for some people. And in doing so, when we're developing these processes, we need to keep in mind, as Samantha was saying, that we're not re-traumatizing Black workers along the process. So that's one way. And another way is through organizing and mobilizing. For example, there's a lot of mobilization around getting disaggregated data. So this is the data that is broken down to help us identify specific outcomes for Black people versus other racialized people, as an example. And the Federal Black Employee Caucus is an example of a group that was advocating for years around this. And so we need to be engaged in mobilizing for legislation reform in many areas, including improving these recourse mechanisms. And internally within the labor movement, we need to have a clear picture of our own barriers. How many local union executives are Black? How many grievances are being filed by Black members? How many of these grievances are being supported right through to arbitration? We need to start keeping track of how well we're doing as a union in the labor movement. And we need more Black folks involved in locals. I truly believe this. This is where decisions are being made that directly impact you. And for those out there who want to be allies, I think you need to ask yourself whether you're encouraging Black, Indigenous, and other racialized people with their various intersectionality to get involved in the union. Ask yourself whether you're stepping back when needed to provide that space for others. And more importantly, are you actively organizing around anti-Black racism in the workplace in your internal practices? Because I know in PSAC, we have committees and regions like the Racially Visible Action Committee, RVAC, that provide workers support and have been organizing around systemic racism. And we're also seeing autonomous groups forming in workplaces, even within PSAC staff. And these groups are independent of unions and formal committees, and they're pushing for systemic changes. So these are some of the things that I would identify.
Thanks, Amarkai. Doug, so what does the future look like to you? How can we use these mechanisms to make things better?
And I'm just going to elaborate a little bit on what Amarkai talked about with respect to the systemic issues. In my discussions with the lawyers that are involved in the class action lawsuit, one of the biggest barriers has to be under Section 10B of the Canadian Human Rights Act, which involves when an employer's policies and practices deprive individuals or a class of individuals from employment opportunities on a prohibited ground. And it's my understanding the class action lawsuit is about just that, that going back well over 25 years, that you have a class of individuals, in this particular case, Black individuals, that have been deprived the opportunity to be promoted, which in and of itself is a violation of Section 10B under the Canadian Human Rights Act. So you have that additional test above and beyond the three-part test that was established in the Christian Reeves decision. And you also have that test in the face of the Prime Minister clearly stating that there is systemic racism within the federal government. So dismantling, I'm not sure if anyone had the opportunity to hear Angela Davis yesterday on the panel, but she talked about dismantling the structures, dismantling the systemic racism that exists as a barrier. And those are things I think that the class action lawsuit is geared towards when you talk about multiple people and the systemic racism within the federal government. When you dismantle those structures, then you're overcoming barriers. Additionally, I would say that, when people are contemplating filing grievances and human rights complaint, that, reach out to someone within the Representation and Legal Services branch and ask for advice, ask for proper wording, ask about time limits. Those will prevent preliminary objections from the employer side.
Thank you very much, Doug. We're going to move to some of the questions that we receive. And I see we receive a number of questions relating to settling cases. And question number one, would you be able to address the reasons why so many cases are settled? Specifically, what are the pros and cons of settling cases? And I don't know if you guys can start or take it.
Maybe I can handle that. Over 70% of my cases get resolved. There are pros and cons to resolving cases. Number one, quite often when you resolve a case, it gets done so in a much more timely manner than being placed on the hearing schedule. Hearings now are being heard 2 years down the road. Resolving cases also helps to put closure to the issue in an earlier possible stage rather than prolonging the pain and suffering, if you will. Quite often resolving cases helps reunite a broken working relationship. Mediation is done in confidential, usually with a skilled facilitator, to really put the issues out on the stand. And I really am a big fan of mediation. Resolve things at the earliest possible stage. Going to adjudication, getting decisions, yes, that's wonderful when the parties' heels are dug in, but there's a great deal of benefits. I'm not sure if Amarkai has or Samantha has anything to add to this.
Samantha, do you want to go next?
No, you can go ahead.
So I think also when you think about mediation, we have the ability to have some control over the process. So we could decide what kind of mediation we want to have if all parties agree, and it could be less adversarial. It could be a way where the member who has suffered harm has more control over the process in terms of the times, in terms of the breaks that they need, in terms of having a voice there. So those are things that are possible. And when you sign off also on a settlement, it's a guarantee. You've read it, you've thought about it. In there could be things that you wouldn't necessarily get at a hearing, but that are meaningful and important to you, versus going to a hearing where you have a third party who's going to make a decision that maybe none of you will like, or maybe one party will like or the other. So there's more control in the system sometimes around settling. And what I would say, and Samantha mentioned, is that oftentimes you don't hear about it. And so that's a negative aspect about it. So I still try to approach settlements, even though they are individualistic and from person to person. Is there a way to get some kind of systemic remedy out of it? And I think when we approach settlements that way, that's where sometimes you could have that public impact, although it is in an individual case by case setting.
Are you going to weigh in, Samantha?
I wasn't, but I really like what Amarkai just said. And the only thing that I would add is that it just depends on what your needs are, right? And so there's no one size fits all. It depends. There might be someone who really doesn't have a lot of money. And so whether the settlement is good or bad, it's just what they have to do. There are some folks that it's not about the money, it's about making a point. So I think that it's really hard to determine whether or not mediation is good or bad. It really depends on the circumstances surrounding it. And the problem is that I would also like to add is that not everyone necessarily has a choice. And so I think that's also something that's important to note.
Well put, Samantha, well put. That's very brilliant, thank you. The other question that I'm going to ask that came in is, what step can we take to shift responsibility for the safety and well-being of Black and racialized workers to people with privileged identities and away from the people experience oppression? That is through recourse mechanism, which can often be traumatizing. I'll repeat that. What steps can we take to shift responsibility for the safety and well-being of Black and racialized workers to people with privileged identities and away from people experiencing oppression? Who want to take that one? It's open. No one? I see maybe.
Absolutely. If I understand the question correctly, is what steps can we take to shift responsibility from those that are privileged?
Yes, I'll repeat. What steps can we take to shift responsibility for the safety and well-being of Black and racialized workers to people with privileged identities?
Right, right. So when you talk about issues of safety in the workplace and anti-Black violence and anti-Black discrimination, I'm going to give a very basic scenario, is that you have the right to refuse unsafe work. And I'm going to give a very basic example. If the building is burning down and the employer orders you to run into the building, right, to grab a document off the desk, you have the right to say no because it's unsafe to do so. That's a very basic example. But there's also other examples when we talk about people's safety. I just spoke about mental health and safety. This issue of safety in the work environment is something that is progressing as we see different forms of violence and anti-Black violence. We've seen it all played out over the media within the last year. And this is something that is making its way through the collective agreements, through the Health and Safety Act, whether or not, and someone just spoke about it, whether or not violence and anti-Black violence, can be construed as an unsafe work environment. Amarkai talked about earlier about people have a right to work in a healthy and safe work environment. We also have language under our collective agreements that says you're not to be discriminated on based upon your race, your sex, your sexual orientation. So the steps that we can take perhaps start at the negotiating table, as bargaining unit members, recognizing that this anti-Black violence is actually progressing in our workplace and the mental health, the effects that it's having on us, and the fact that it's becoming unhealthy for us to work in this type of environment. Perhaps we need to have specific language in our collective agreement at the bargaining table That's a step. If there's language already in your collective agreement, you can take a step back, as Marilyn Duro did, took a step back and went to see a psychologist only to be reimbursed her medical expense. As Juliet English Baker, you know, it was determined that it was discrimination for non-culpable behavior. So, and I hope I'm answering the question in the broader sense when I'm talking about anti-Black racism.
I think you did that. Thank you very much. And did Samantha or Amarkai want to weigh in?
Sure. If I understand the question correctly, one of the things that I would say is being cognizant of the ways in which we have these discussions. So what I mean is that, for instance, I've been in situations where I've experienced anti-Black racism in the workplace, and it was perpetuated by a white person, and they wanted to have an informal discussion about it, right? However, if I, was speaking in a way that they saw was aggressive, there was a disciplinary process, right? And so what accountability could look like, or how do we shift accountability or responsibility, is being really careful and cognizant of the processes that we choose to use when it involves particular people. Because having an informal discussion about anti-Black racism doesn't necessarily address anti-Black racism in the workplace, right? And so I think that might be one way to shift accountability, is to have perhaps a more formalized conversation and formalized consequences of anti-Black violence, rather than just sweeping it as something like, they didn't know, and having just an informal discussion about something that's actually very serious, very violent, and as Doug and Amarkai have talked about, has real and material consequences on our lives.
Perfect, well put. Amarkai, are you gonna weigh in or?
Yeah, I'm just gonna say, like, I agree with what was said by my fellow colleagues, and that, I think we're at a position where we could start reimagining what recourse mechanisms can look like, right? Knowing that we could negotiate some of them. And so having those that put survivors at the center, what are those processes? And like Samantha said, it may be different based on different situation, but having the ability to structure it. And I think that's something that we need to start putting our mind to, and start being creative and thinking about that, really having a survivor center approach to how we think about recourse mechanisms.
And that was the perfect segue into our next question, which is, please tell us some of the things that white union leaders can do to fight, example, anti-racism, to fight anti-racism, especially in supporting Black workers through recourse process or workplace racism. Any takers? All right, I'll repeat again. For clarity.
I can start. One of the things I think that would be helpful is providing us Black workers with what their options are. I've been in workplaces where I didn't even know what to do if I experienced anti-Black racism in the workplace until it actually happened, right? And so I think that unions can support workers by being upfront and letting us know about what the process is, pros and cons of processes, so we can make informed decisions and informed choices. Because sometimes your back is against the wall and you make decisions that you may not have wanted to make. So I think that having that information upfront would be really helpful in order to support Black workers, so that we can make informed choices about what would work best in that particular situation.
Thank you so much for that. Anyone else?
Yeah, I'll add that two things perhaps. I'll go back to the Christian Reeves decision, and if I understand the question correctly, is what can white allies do to help with issues of anti-Black racism? This is a rather sensitive issue, but at the same time, it's a very relevant issue, because in watching the media, I've seen so many different ethnicities during the protests: white people, brown people, Black people, Asian people, all marching for anti-Black racism, for the Black Lives Matter movement. It wasn't just Black people. And I'm thinking back to the Selma incident when they first marched over the bridge. It was predominantly Black people. It wasn't until other races got involved, in particular white races got involved, and they were not brutalized, because then the value of brutalizing white people on TV was not a good thing. But it goes to the statement, I believe, with respect to Black Lives Matter. And in the Christian Reeves decision, there were a number of allies that came forward on his behalf to tell the truth. One supervisor in particular, changed his statement because he wanted to be promoted. He was promised a promotion on Christian Reeves' back. If you give this false statement about Christian Reeves, you will be promoted off of the list. And he did give the false statement. And then he recanted it out of guilt. And he wasn't promoted. Being honest, being truthful. We don't always need white people to fight our battles for us. That is, you do not have to step up and say this is wrong, in the sense that because I'm white and saying it's wrong, I bring more credibility to your argument. Sometimes you need to step back and let us be the ones to take the step, or step beside us, side by side, as an ally, and understanding what that allyship really means.
Thank you so very much, Doug. In the interest of time, Amarka, did you want to weigh in, or can I move to the next question?
I'll just say one question.
Yes.
How can I support you?
Mm-hmm. Yeah.
Well put. Well put. And just looking at the next question and on Doug's answer before this, the next question is asking, after a settlement or the recourse process is done, but the workplace racism continues, what can be done?
Well, a settlement deals with your specific circumstances. And in the settlement, there are certain terms. And I'm going to once again refer back to the Christian Reeves decision. We also, when Christian Reeves was reinstated, one of the things that D&D should be proud of that they did correctly, when the adjudicator ruled that there was a campaign against Christian Reeves, and we went back to reinstate Christian Reeves into an environment free of discrimination, D&D got rid of all 10 people that were involved in that campaign. They were either transferred out or lost their job, including the labor relations person. This is all in a public decision. People were transferred for their involvement. And I apologize to go off on a bit of a rant sometimes. Repeat the question.
After a settlement or the recourse process.
Right. So the terms of settlement are specific to your incident, right? And if your terms have been breached, there's a breach of a settlement. But if after your settlement, you experience a different or a separate incident of discrimination, you can file another grievance. You can file another harassment. I realize, that you have collective agreement language that says you have the right to work in an environment free of discrimination, but the settlement has to do with perhaps one specific incident of discrimination. So if it happens again, file another grievance, file another human rights complaint.
Okay, thank you very much for that, Doug. As federal employees, we sign a code of ethics to not speak badly about our employer. Does this thus mean that speaking out about injustices by the employer, perhaps outside of a grievance or other process, could lead to suspension or termination? It's open for any one of you guys. Do you want me to read again? As federal employees, we sign a code of ethics to not speak badly about our employer. Does this mean that speaking out about injustice by our employer, perhaps outside of grievance or any other process, could lead to a suspension or termination, etc.?
I could start with this one. I mean, each situation will be fact specific. If you do work an employee, you always have this duty of loyalty, you know, to your employer. At the same time, if you're being asked to, you know, breach laws in your actions, or there is illegal activity going on and you want to speak out against that, there are some protections around what's called whistleblowing. Oftentimes, and I'll just go back to settlements, right? So when you see a grievance complaint or a human rights complaint, oftentimes you see language in there that no one could discuss the terms of the settlement. And so sometimes what I've tried to negotiate is saying, well, this is somebody's history. They should be able to speak to parts of that, right? It's part of their identity. It's part of their healing process in some ways, to talk about what they went through, and so trying to push it that way. And so it's really case by case, but those are kind of the perimeters around that. I don't know if Samantha or Doug want to weigh in.
Okay, thank you so very much for that, Amarkai. And at this point, I just want to give a 10-minute warning. We have about 10 minutes remaining. I see that we have a lot of questions coming in, and we'll try our best to get to them. If we don't, just please bear with us. I do realize this is a very meaningful discussion that's going on, and truthfully, I wonder why something like this didn't happen even before, with all the information that we're getting and such. The good thing about this is that this will be recorded, and it will be available on the PSAC website. So yeah, in the interest of time, as I said, we have about 9 minutes left, and I want to make sure that all our panelists get at least a last word in. So I'm going to ask the last question, and then I'm just going to do a final take, okay? So the last question: what do you do if your rep doesn't want to file a grievance or deal with workplace racism? What can you do?
Amarkai spoke earlier about the duty of fair representation. And he referred to historically the fact that legislation was enacted as a result of the fact that Blacks were not represented. Duty of fair representation means that your union cannot act in a manner that is arbitrary, discriminatory, or in bad faith. And the word discriminatory is in there for a reason, right? If you look at the definition of discrimination under your collective agreement, there are 11 prohibited grounds, race being one of them. So if you come to your union with a clear set of facts and your union doesn't want to file a grievance, you can alternatively file a DFR complaint against your union. But there needs to be clear, compelling, concise information. And it's not necessarily has to do with the merits of the case, but more has to do with the way in which the union is dealing with you. And that is the 3 terms that you need to be familiar with in DFR is arbitrary, discriminatory, or in bad faith. And what the scenario that you've laid out there sounds like an arbitrary decision. If you come with an allegation of discrimination in your work environment, your union has the obligation to investigate it. They can't just arbitrarily say, no, we're not filing agreements. They have that legal obligation to investigate.
Great. Thank you very much, Doug. Anyone else?
Sure. I would say that, I was talking earlier about the committees that we have in our different jurisdictions. So there's RVAC, the Racially Visible Action Committee. who have been very supportive around members and being there, right beside members to push some of these cases when they feel that maybe their union rep isn't understanding. So I would say it's part of the mobilizing, organizing together within the union and with other folks who may have been through what you've been through. So I would say contacting those committees within the union, within the local or within sometimes the larger structure of the union. There are places where you could take your questions above. So a union rep, it's a shop steward that's not understanding. Maybe there is the president that you could speak to, the local, and have a meeting with them and discuss those issues. And so I think we also have mechanisms within our union structure that could push some of these issues. We have, Doug mentioned it earlier, in terms of expertise within the union. So our programs branch has human rights officers who deal with these and who field questions from union reps. And so we have a lot of resources within our union to provide that support when we're getting those interior barriers that I was talking about. So I think I would suggest some of those recourses.
Thank you very much, Markai. So what I'm going to do next, starting with Samantha, I'm going to afford you guys a minute each, just to say your final words, and we'll wrap this up, okay? So Samantha?
Hi, I just wanted to thank everyone for engaging and for sharing space and talking about this really timely and important issue. I just wanted to add that, when we talk about workers' rights, it's really important for us to consider all of our options and not feel inclined to make particular decisions based on pressures from unions, for instance, that may not understand your specific experience with anti-Black racism. I think it's really important to connect with your community and your loved ones so that you can make informed decisions, so that you can exist in a workplace and feel safe and supported.
Thank you very much. Doug?
I would just like to say to the listeners that, we're talking about the issue of anti-Black racism and racial discrimination in the workplace. We provided you with some recourse mechanisms. We've provided you with some options, including mediation. As isolating as this experience can be, I want you to realize that you're not alone, okay? PSAC staff in the Representation and Legal Services branch are there to support you. We offer training to the components. We offer training to the locals. It's part of my job description to give advice on a grievance. Pick up the phone, give us a call. I can't help but continue to reflect back on the Christian Reeves decision, which was truly a David and Goliath type of situation, where here he was escaping civil war in Liberia to come to Canada to have a better life, and went through this program with D&D. D&D is the largest federal employer in Canada. There's Goliath that had a campaign to discriminate against him, and he was isolated and felt so alone. But when the decision came out, he and I both cried as a Black man. I cried when he testified. That's the impact that it had on me. It's rewarding. You're not alone. I know there's a number of people out there that are experiencing this, but you have the mechanisms and you have the support, so reach out.
Thank you very much, Doug. Markai?
Yeah, thanks to everyone who organized, the interpreters. Thanks to all of you that are participating, the panelists. I'm honored to be here, and I see hundreds of participants. And I hope all of you are shop stewards or in your union executive, and that you're involved because you're clearly interested in bringing about change in our union. So first step. You've heard maybe some new things today, and I really hope that you engage in the unions, be involved in the different committees. The union is you. I think we often like to talk about a union as this, third party, this institution out there, but it's also us as individuals. It's you as individuals that make the union, that decide on the policies, that are able to bring up real change. So I hope that the hundreds of you that are on this webinar, we're going to see you in the workplace, fighting and advocating and making sure to challenge anti-Black racism wherever you see it.
Thanks, Markai. And just so that you guys know, there are lots more questions that we didn't get to, and we will try to gather some of those questions and provide it in some kind of a resource document. I want to thank all our panelists and all the PSAC staff who helped to put this webinar together. And most of all, I want to thank you, the PSAC members who joined us tonight. Good night all, stay safe.